Hey everyone, and welcome. Today we are diving headfirst into a really high-stakes legal battle that's brewing in India. And really, it's a classic conflict for our digital age. The public's right to know, squaring off against every single person's right to privacy.
And this, right here, is the question at the very heart of the debate that's now before India's Supreme Court. So let's keep this in mind as we start to unpack all the arguments.
Okay, let's get right into it. There's a brand new law, one designed to protect all of our data, and it's already facing this massive legal challenge just as it's getting off the ground. So what is really going on here?
The law at the center of this whole storm is the Digital Personal Data Protection Act of 2023. You'll hear it called the DPDPA for short. Now, its goals sound simple enough. Create a solid framework for protecting the personal data of everyone in India.
But, almost right out of the gate, it got challenged. We're talking journalists and civil liberty activists filing petitions with the Supreme Court, and they're arguing that this new law creates a huge roadblock. Their main claim, that the DPDPA seriously weakens the Right to Information Act, which, as you know, is this landmark law that for years has let citizens hold the government accountable. They believe that by shielding more info under this big banner of personal data, it's actually damaging our fundamental right to freedom of speech.
But look, this whole conflict didn't just pop up out of nowhere. Nope, it's been building for years. A really key turning point was back in 2017, when the Supreme Court officially declared the right to privacy a fundamental right. And that one decision, well, it pretty much set the stage for the DPDPA law in 2023, and of course for the very court challenges we're talking about today.
So in this whole debate, one of the key voices defending the new law is a group called the Foundation of Data Protection Professionals in India, or FDPPI. And what's wild is they actually saw this exact clash between information and privacy coming years ago.
Just take a look at this. This quote is from one of the FDPPI's founding objectives, way back in 2018. They explicitly said their goal was to bring harmony between these exact rights: privacy, freedom of expression, and the right to information. They totally knew these ideas were going to butt heads eventually.
All right, so let's get right to the heart of the disagreement. What are the core legal arguments being thrown around on both sides of this information versus privacy debate? Let's break it down.
So on one side, you have the petitioners. They're arguing that the right to information, or RTI, has always been seen as this incredibly powerful tool, absolutely essential for holding power in check. But then on the other side, you've got the FDPI. And they're saying, hold on a minute, that 2017 Supreme Court privacy judgment completely changed the game. In their view, RTI can't be an unchecked power anymore. It has to be balanced against the equally fundamental right to privacy.
And here's the kicker, the real key to understanding their point. The FDPIPI points out that when the RTI law was passed back in 2005, privacy wasn't a constitutionally protected fundamental right. So they argue this gave RTI a kind of free rein of interpretation that just isn't valid anymore in a post-2017 world. It's like the legal ground has literally shifted beneath our feet.
Now, to really get the FDPI's argument, we got to get our heads around this one term, a derivative right. It's pretty simple. Think of a big fundamental right, like freedom of expression, as the main trunk of a tree. A derivative right, like the right to information, is like a major branch that grows out of that trunk. It's strong, it's important, but it comes from something more primary.
Okay, so here's the bottom line from the FDPPI. Since both the right to information and the right to privacy are seen as these powerful derivative rights, neither one can just automatically claim it's more important than the other. A balance has to be found. It's not about one right winning. It's about figuring out how they can coexist.
Okay, so that's all the legal theory. But what does any of this mean for us, in the real world, for people using the internet every single day? Let's dig into the practical side of this whole debate.
Yeah, this question really cuts to the chase, doesn't it? When we talk about making exceptions for journalism, who are we actually talking about? Because that definition, it's not as simple as it used to be.
While the FDPPI's take is that in today's world, a journalist isn't just someone with a press pass from a big newspaper. It could be a blogger exposing local corruption, a YouTuber making a documentary, or even someone with a big Instagram account or a WhatsApp channel sharing vital information. The definition just has to evolve with the technology.
And this brings us to a really important shift in thinking here. According to the FDPI, the DPDPA doesn't give special treatment to a specific profession. Instead, it focuses on the purpose of what you're doing. So what does that mean? It means if you're processing data for journalistic reasons, you could be eligible for an exemption. It doesn't matter if you're a YouTuber or if you work for a major newspaper. It's about what you're doing, not who you are.
So, if we know these two powerful rights are just going to keep clashing, how do we actually solve the disputes when they happen? Well, the FDPPI is proposing a whole new way forward, one that moves away from the old system.
This table really lays it all out. See, under the old system, a dispute over an RTI request went to an information commissioner who's an expert in administrative law. The new proposed path sends a conflict like this to the new Data Protection Board, a group with specialized expertise in data law. The whole argument is that these aren't just simple administrative appeals anymore. They're complex data protection grievances.
And you know, this quote right here, it just perfectly sums up the FDPI's entire philosophy. It's a call for balance, a call for recognizing that in our digital world, transparency and privacy, or the right to information and the right to privacy, they just have to find a way to coexist.
And that really leaves us with the big question. Sure, this case is about India's laws, but the dilemma itself is global. As more and more of our lives and our data move online, every single society has to wrestle with this. Where do you draw that incredibly fine line between the public's right to know and an individual's right to be left alone? Definitely something to chew on. Thanks so much for joining me.